Hello, viewers. Today's lesson has been inspired by the current situation in which sex videos are being shared on social media. And in addressing this present issue, we shall be looking at four main areas. Firstly, we shall be looking at the legal description of sex videos. Secondly, to find out the law that prohibits the sharing of sex videos. Thirdly, to identify the loopholes, if any, and lastly to recommend areas that require amendment. Now, the word sex videos have been deliberately used as we are yet to find out whether it is the correct legal description in the laws of Sierra Leone. Now, to the description of sex videos. Under the Sexual Offences Act of 2012, looking specifically under the interpretation section, certain videos have been described under that interpretation section. The first has to do with indecent material. Indecent material is defined as any photograph, video, including data stored on a computer disk or by other electronic means that offends against recognized standards of propriety and cultural values. Secondly, child pornography has been defined as any photograph, video that shows a person who is depicted as being under the age of 18 and is engaged in or is depicted as engaged in sexual activity. Now, these are the two definitions that could be likened to that of sex videos. However, though the act doesn't specifically indicate sex videos, but these definition of indecent material and child pornography can be likened to sex videos, though it is not legally correct to reach that conclusion. Now, what is the law that prohibits sharing of sex videos? Now, a person who makes, publishes any indecent material, distributes or circulates or shows the indecent material commits an offense and is liable on conviction to a fine not exceeding 20 million yuans or to imprisonment for a term not exceeding 5 years. Now, we are looking at indecent material in this situation, and the indecent material as earlier defined includes a video, and it is an offense if one produces it, that is, makes it, publishes it, or even distributes or circulates it. It is an offense and incurs a punishment of a fine of 20 million yuans or imprisonment for a term not exceeding 5 years. So the very production and sharing of that indecent material is an offense in itself. Now, what are the loopholes in respect of sex videos, the sharing of indecent material in Sierra Leone? Now, in the first place, adult pornography is not defined by the act. In other words, though child pornography has been defined, the act is however silent on the definition of adult pornography. It however defines indecent material. Now, secondly, indecent material definition is not sufficient. It is not sufficient because it has to be one that offends propriety or cultural standards. Now, we are yet to know the ambit or scope of this description, which means that cultural standards vary from community to community and from person to person. This makes its objectivity very difficult to establish. Hence, the subjectivity of this description is wide beyond imagination. Now, lastly, the different mediums of circulation is not clear. This means that though the indecent material has been defined and child pornography has been defined, the medium through which the sharing of the said indecent material should incur liability is not clear under the Act. Now, areas of amendment. It is recommended, therefore, that there be a clearly defined definition for adult pornography. a clear, defined legal definition for adult pornography, to be specific. And secondly, to specify the medium of circulation, that is, which medium are identifiable under the offense of circulating indecent material. Is it on social media, or is it other platforms through newspaper or TV or any other platform that is recognizable? Thank you for listening. Thank you for watching. Please don't forget to subscribe, hit the notification bell, drop your comment, and share. Thank you.